La Cour.
Please be seated. Good morning. The sitting is now open. The court meets this morning to hear the following participants: South Africa, Algeria, Saudi Arabia, Belgium, and Colombia. Each of the delegations has been allocated 30 minutes for its presentation. The court will observe a short break after the presentation of Saudi Arabia. I shall now give the floor to Mr. Dango, speaking on behalf of South Africa. Sir, you have the floor.
Mr. President, members of the court, it is an honor to appear before this court on behalf of the Republic of South Africa. We appear before the court pursuant to General Assembly Resolution 79/232, which requested an advisory opinion on the obligations of Israel in relation to the presence and activities of the United Nations and other international organizations and third states. This resolution was initiated by Norway and supported overwhelmingly by member states. We make these submissions while Gaza is once again under a complete siege following Israel's breach of the ceasefire brokered by the United States, Qatar, and Egypt. Israel has also intensified its aggression against Palestinians in the West Bank. Israel is blocking food, water, and medicines, all of which are essential to life, from entering Gaza. As cited in this court yesterday, the United Nations Secretary General stated that Gaza is a killing field. He added, "Aid has dried up, the floodgates of horror have reopened." On 11th April, the UN Office of the High Commissioner for Human Rights reported that Israel, and I quote, "appears to be inflicting on Palestinians in Gaza conditions of life increasingly incompatible with a continued existence as a group in Gaza." Palestinian NGOs and major aid groups have warned that Gaza is entering into famine and that, in their words, the humanitarian aid system is facing total collapse. This collapse is by design. Israel's Defense Minister, Israel Katz, said on 16th April 2025, and I quote, "Israel's policy is clear. No humanitarian aid is about to enter Gaza. There are no preparations to enable such aid." Under the world's watchful eye, Palestinians across the occupied Palestinian territories are being subjected to atrocity crimes, persecution, apartheid, and genocide. While we watch, the gaze of Palestinians is directed squarely at the international community and this court, whose advice is urgently being sought for the protection of their most fundamental rights, including the right to life. The scale of the harm inflicted on Palestinians by Israel was laid out in detail in oral submissions made yesterday. We wish to emphasize the impunity with which Israel is inflicting these harms. Israel continues to act with impunity as it does enjoy some form of exceptionalism from accountability to international law and norms. Conversely, any person or entity which seeks to hold Israel to account for its inhumane and unlawful actions is subjected to countermeasures and censure, from which the United Nations and this court has not been spared. In this context, the United Nations Relief and Works Agency for Palestinian Refugees, UNRWA, which was established after the 1948 Nakba, is but one of Israel's latest casualties. UNRWA is being attacked in furtherance of Israel's goal to deny the inalienable right of return of Palestinian refugees, the restitution of their land, homes, and property appropriated since 1948, and to further its apartheid policies and practices. The attacks on UNRWA are also deliberately imperiling the existence of Palestinians as a group. Mr. President, members of the court, turning now to the court's jurisdiction, South Africa considers that the court's jurisdictional requirements have undoubtedly been met. In relation to judicial propriety, South Africa observes that the court had, in its 19 July 2024 advisory opinion, dispensed with the arguments raised by some states in this proceedings. The court held that the arguments did not constitute compelling reasons to decline to give the advisory opinion then. The same reasoning should apply now. In the interest of brevity, South Africa will not repeat the court's long-standing and clear jurisprudence on this aspect. Providing an advisory opinion does not require the court to prejudge elements relevant to the contentious proceedings in South Africa versus Israel, which South Africa argues, based on facts and law, that Israel is in breach of the Genocide Convention. The question asked of the court in the present matter concerns Israel's obligation as an occupying power and its obligations as a member of the United Nations, and specifically the legal consequences arising from its acts and omissions in these contexts. The court has extensive facts available to it by virtue of the dossier transmitted to it by the United Nations and the submissions made in writing by states. This is despite Israel imposing an information blackout, including through prohibiting the entry of international media and by killing journalists. Israel is also denying access to the occupied Palestinian territory to UN agencies, persons and entities mandated by it to investigate Israel violations of Palestinian rights. Accepting Israel's argument under the circumstances that this court has insufficient facts before it would be rewarding it for its own egregious conduct. Any further actions by Israel that censor remaining humanitarian organizations requiring access, UNRWA in particular, would contribute to rendering Israel's conduct unreviewable. The international community cannot accept the reality in which an entire civil population is deliberately starved by Israel, where the United Nations is evicted and deprived of its immunities and privileges, where third states and humanitarian organizations are prevented from rendering humanitarian assistance in solidarity and in fulfillment of their erga omnes obligations. Nor can we accept that journalists, aid workers, and first responders are being assassinated and then hastily buried in mass graves. The United Nations is rightly seized with this matter and calls for the court's urgent advice on the questions put to it by the General Assembly. Mr. President, members of the court, this brings to an end the first part of South Africa's oral submission. I kindly request that the court calls upon Ms. Nokukanya Jele, the Special Advisor to the President of the Republic of South Africa on Legal and International Affairs, to address it on Israel's obligations as an occupying power. I thank you for your attention.
I thank Mr. Dangor. Je donne maintenant la parole à Madame Nokukanya Jele.
I now give the floor to Ms. Okanya Njele. Please, you have the floor.
Monsieur le Président,
Mr. President, members of the court, it is an honor and a privilege to speak here to you this morning on behalf of South Africa. In an international legal order that prohibits the acquisition of territory by force, The international law rules governing military occupation must by necessity be interpreted in favor of the rights of the occupied population.
Est reste sous l'occupation militaire d'Israël et le droit de l'occupation s'y applique en vertu de la lex specialis. Partant de ce postulat, le droit de l'occupation impose des limites à l'exercice.
I'm sorry. The interpretation.
Can you hear the English translation?
Yes.
I shall do so, Mr. President. Monsieur le Président, Mesdames.
Mr. President, ladies and gentlemen, members of the court, it's an honor for me to present myself here this morning on behalf of South Africa in an international legal order that prohibits the acquisition of territory by force. The international law rules governing military occupation must, by necessity, be interpreted in favor of the rights of the occupied population. The Gaza Strip and the West Bank, including East Jerusalem, remain under Israel's belligerent occupation, and the law of occupation applies as a matter of lex specialis. Proceeding from this premise, the law of occupation imposes limitations on the de facto exercise of the occupant's power. It invests in the occupying power, as this court observed, a set of regulatory powers on an exceptional basis and on specific enumerated grounds. Israel is under an obligation to respect the lives, rights, and property of the population of the occupied territory, while protected persons cannot be deprived in any manner whatsoever of the benefits of the Convention by any change introduced as a result of occupation. In 2024, the court declared that it is, I quote, not convinced that the extension of Israel's law to the West Bank and East Jerusalem is justified under any of the grounds laid down in the second paragraph of Article 64 of the Fourth Geneva Convention. South Africa submits that the UNRWA banning laws are also to be declared inconsistent with this provision. Firstly, through these laws and their direct territorial application to occupied Jerusalem, Israel unlawfully purports to assert sovereignty over East Jerusalem. As the law of occupation does not transfer title to assume sovereignty to the occupying power, through this additional measure, Israel extends, as this court opined, I quote, its gradual annexation to Israeli territory and the application of its domestic laws therein, thus impeding the exercise of the right to self-determination of the Palestinian people. Secondly, the occupying power is not entitled to exercise its limited powers in a manner inconsistent with its other obligations under the Convention, cited in great detail by Palestine yesterday. Israel may not impose any measures specifically prohibited by international humanitarian law, such as mass forced displacements, the destruction of property, transferring in of colonial settlers, targeting schools, and even targeting the school curriculum to erase the history of the Palestinian people. Israel is not entitled to subject the population to collective punishment while indiscriminately bombing civilians and civilian property on a large scale, acts which are manifest violations of its obligations as an occupying power. Thirdly, as part of its duty to ensure public order, to protect the lives and security and safety of civilians, Israel must act in a manner consistent with its obligations under international humanitarian and human rights law, which prioritize the well-being of the Palestinian population. This includes not preventing, impeding, or restricting collective relief schemes, which Israel shall agree to and shall facilitate by all the means at its disposal, without exception. This includes respecting the privileges and immunities of the United Nations, which operates such relief schemes, as well as allowing entry into and movement within the occupied Palestinian territory. Any dismantling of Palestine's quasi-state institutions, including those administered by UNRWA since 1949, would risk resulting in a complete breakdown of public order and civic life, and would be an act, and is an act clearly intended to destroy the viability of the Palestinian state. Such a decision would target constituent parts of the Palestinian housing, education, and healthcare system. The dissolution of such institutions is prohibited under Article 47 of the Fourth Geneva Convention, as part of its obligation to bring to an end its unlawful presence in the occupied Palestinian territory as rapidly as possible. Israel must halt its unlawful administration over movement and entry into the occupied Palestinian territory under jus ad bellum. Mr. President, members of the court, several states have in their written submissions outlined Israel's affirmative obligations under the Fourth Geneva Convention. Israel retains primary responsibility for the implementation of its obligations under the provisions of that convention. No exception or qualification is provided for in these provisions. Article 69 of Additional Protocol 1 expands the nature of the goods that are to be supplied, taking into account local conditions. These unqualified obligations include an obligation on Israel not to obstruct entry into and freedom of movement within the occupied Palestinian territory of humanitarian relief personnel. The occupying power also cannot refuse to allow and facilitate the rapid transit of humanitarian aid through its territory as relates to relief equipment and personnel essential to the survival of the civilians. Security Council Resolution 2720 of 2023 demanded the full implementation of Resolution 2712 of 2023, which called for the provision, I quote, of inter alia water, electricity, fuel, food, and medical supplies, as well as emergency repairs to essential infrastructure, end of quote. It also demanded that all parties comply with their obligations under international law, including international humanitarian law, and called for access, unfettered access for United Nations humanitarian agencies and their implementing partners. The court's orders of 26 January, 28 March, and 24 May 2024 constitute additional legal obligations for Israel to allow and facilitate the unimpeded passage of humanitarian aid into the Gaza Strip, I quote, in full cooperation with the United Nations, end of quote. However, Israel has blatantly ignored these binding obligations. Instead, 1.5 months after its legislation banning UNRWA went into effect, it has intensified its denial of aid by imposing a nearly 8-week-long blockade on Gaza. South Africa has published 2 public dossiers which set out in detail, amongst others, Israel's denial of aid policy. UNRWA is not engaging in, and I will quote their written submissions, is not engaging in a one-sided politicized advocacy, but rather acting in accordance with its obligations recognized by the UN General Assembly as a, I quote, global advocate for the protection and care of Palestine refugees, end of quote, along with the UN's customary obligations not to recognize as lawful the unlawful presence of the State of Israel in the occupied Palestinian territory. Israel's allegations are calculated and deliberate in a context in which Israel has imposed a blanket ban on all humanitarian organizations and the delivery of humanitarian relief to Gaza by third states. This includes new restrictive procedures seeking to further shutter any humanitarian organizations operating in the occupied Palestinian territory. Mr. President, members of the court, South Africa submits that sovereignty is always retained by the people of an occupied territory. The people of Palestine, through their chosen representatives, have consented to receiving humanitarian aid and to the presence and activities of the UN and third states in the occupied Palestinian territory. The law of occupation, and in particular, Articles 59 to 61 of the Fourth Geneva Convention, do not require an occupying power's consent in cases where the civilian population is inadequately supplied. It is therefore the law of occupation, and particularly Articles 55 to 61 of the Fourth Geneva Convention, which are applicable to the occupied Palestinian territory, requiring Israel not only to, I quote, enable, but also to, I also quote, ensure the provision of aid and basic services. Further, Article 11 of the Fourth Geneva Convention clearly envisages a role for humanitarian organizations as substitutes for protecting powers for the protected civilian population. The United Nations have continued to play a protecting role for the benefit of the Palestinian people, who were guaranteed full self-determination as a Class A mandate and were subsequently dispossessed of their territory and forcibly displaced during the Nakba in 1948, which made necessary the creation of UNRWA to guarantee the rights of Palestinian refugees, including the rights of over 70% of Palestinians in Gaza, who have been systematically denied their right to return to their homes. As part of Israel's unlawful occupation, Israel is completely ignoring its need to fulfill its obligation as an occupying power, but rather it seeks to wrongfully usurp rights. Israel's conduct and admissions clearly violate the law of occupation as a whole, and its grave breaches of international humanitarian law cannot be allowed to persist. Mr. President, members of the court, this brings to an end the second part of South Africa's submission. And so, Mr. President, may I request that you invite Mr. Jamian Hendricks, State Law Advisor for International Law, to address the court on South Africa's conclusions.
Madame Gillet, I now invite Mr. Jamian Hendricks to address the court. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Republic of South Africa. International law prohibits Israel from the use of starvation as a method of warfare, including under siege or blockade. Israel may not collectively punish the protected Palestinian population, which it holds under unlawful occupation. The UN Special Rapporteur on the Right to Food, in his report of 17 July 2024, stated, "Starvation reflects a state's fundamental abandonment of its human rights obligations," and further, that the State of Israel has deployed the full range of techniques of hunger and starvation, perfecting the degree of control, suffering, and death that it can cause through food systems, leading to this moment of genocide. Despite the horrific attempts by Israeli officials to characterize them otherwise, Palestinians are human beings. They are flesh and blood. Palestinian people are entitled to the same fundamental protections as we in this great hall of justice. And this includes the right not to be arbitrarily deprived of life, the supreme right from which no derogation is permitted, even in situations of armed conflict. Israel's humanitarian blockade, including its ban of UNRWA, renders the Palestinian population significantly less resilient to Israel's acquisition of territory by force and of its genocide. In so doing, Israel is breaching the right to self-determination of the Palestinian people, a peremptory norm of international law enshrined in the UN Charter and Common Article 1 of the International Covenants on Human Rights. Furthermore, Israel is impeding the United Nations and third states from exercising their erga omnes obligations and international solidarity with respect to the exercise of the fundamental human rights of the Palestinian people, which this court held to include the right to self-determination. In relation to Israel's obligations towards the United Nations, the 1946 General Convention provides for no exceptions to the inviolability of the United Nations, which applies equally in times of peace and in armed conflict. States are under a legal obligation to protect the inviolability of all UN premises and property, wherever located and by whomever held. Israel must therefore cooperate in good faith with the United Nations and render it every assistance. And despite its abrogation of its bilateral and operational agreement with UNRWA, Israel's obligations under the UN Charter and the General Convention prevail. Mr. President, members of the court, turning now to the legal consequences which flow from the question before the court. South Africa submits that Israel's unlawful occupation and its aforementioned violations of peremptory norms of international law constitute internationally wrongful acts attributable to the State of Israel. This necessarily invokes the law of state responsibility. Israel must therefore immediately cease its internationally wrongful acts and make reparation in full, including through restitution, compensation, and satisfaction. Israel must comply with its obligations as an occupying power to ensure food and medical supplies and facilitate the unhindered provision of humanitarian goods, essential services, and development assistance by the UN, third states, and other international organizations. It must fully cease hostilities to ensure their ability to deliver assistance. Israel must comply with this court's binding provisional measures in South Africa versus Israel and take effective measures to ensure, without delay and in full cooperation with the United Nations, the unhindered provision at scale and by all concerned of urgently needed basic services and humanitarian assistance to Palestinians in Gaza. Finally, Israel must immediately reverse its decision to expel UNRWA and other UN bodies from carrying out their mandated activities. Turning to the obligations on the United Nations, the United Nations and its bodies are under a duty not to recognize Israel's internationally wrongful acts, such as its unlawful eviction of UNRWA and its unlawful powers reserved for the legitimate sovereign in Palestine. And despite Israeli restrictions, the UN and its agencies, including UNRWA, must continue to render humanitarian assistance to the Palestinian people. It must demand and negotiate for the removal of barriers imposed by Israel. Turning to the obligations on third states. Third states have an obligation not to recognize as lawful Israel's internationally wrongful acts, including its banning of UNRWA, not to maintain these acts and to collaborate to bring such acts to an end. It is imperative that third states refrain from providing arms which enable Israel's continued breaches of international law in the occupied Palestinian territory. Mr. President, members of the court, in conclusion, South Africa shares the UN Secretary General's view that the world has failed the Palestinian people. The only certainty they have is that tomorrow will be worse. Therefore, we must save whatever is left of our humanity by ending Israel's unlawful settler colonial occupation and its intentional starving of the Palestinian population, who are being systematically brutalized and deprived of the most elementary considerations of humanity. Palestinians look to the world and to this court for an end to their enduring loss, their pain, and their suffering. Mr. President, members of the court, this brings to an end South Africa's oral submission. I wish to thank the court for your attention.
I thank the representatives of South Africa for their presentation. J'invite à présent la délégation de la...
I now invite the delegation of Algeria to take the floor, and I would like to call to Madame Maya Salih Fadel to make her presentation. Mr. President, members of the court, Mr. President, first of all, on behalf of my country, Algeria, and my delegation, allow me to congratulate you on your accession to the position of president in this very prestigious organization. I have the honor to present on behalf of my country, the People's Democratic Republic of Algeria, the oral statement with respect to the advisory proceedings relating to the UN General Assembly's request of 19th of December 2024. Mr. President, members of the court, without going back over all the facts that have been extensively developed in all the written submissions that have been presented to this court, Algeria wishes to point out that nearly 6 million Palestinian refugees are registered with UNRWA. The agency manages 58 refugee camps and 711 schools attended by 550,000 students. UNRWA operates 141 primary healthcare centers. It also provides a social safety network to 332,763 people approximately, and also provides technical and vocational education and training to 7,800 young people. It has also allocated microfinance loans to 27,199 clients. Since the 2nd of March 2025, a deliberate blockade that has been decided by the Israeli occupying power has prevented the delivery of any food aid to Gaza. Due to this, the Palestinian population is facing hunger, lacking in livelihood and basic necessities. As the General Commissioner of UNRWA pointed out, he said that he was witnessing a man-made, politically motivated famine. The recent massacre of 15 paramedics and ambulance drivers who were Palestinians and whose bodies were found in a mass grave sparked worldwide indignation, without mentioning the numerous attacks perpetrated against women and children in the occupied Palestinian territory. Algeria recalls that the desperate situation in Gaza and the blockade of humanitarian aid are being used today as bargaining chips and weapons of war. Israel's behavior towards UNRWA is predates the offensive that it began in Gaza in October 2023. However, the attacks perpetrated since remain unprecedented. Israel has attacked staff and destroyed the premises, the property, and the assets belonging to UNRWA. It has also taken as a target and killed and detained UNRWA staff. This demonstrates what the policy that Israel has pursued for a very long time, aiming at obstructing its mandate. The adoption of 2 Israeli laws on the 28th of October 2024 perpetuate the hindrance already mentioned, and such a behavior is totally incompatible with the obligations of Israel and as an occupying power and member of the United Nations, as is in total contradiction with the rules set out in the UN Convention on Privileges and Immunities. From a legal standpoint, UNRWA has a unique mandate that covers essential aspects of the Palestinian question, including the right of Palestinian refugees to return and the inalienable right of the Palestinian people to self-determination. Furthermore, Algeria recalls that that Israel is bound by these conventions pertaining to privileges and immunities to which UNRWA is entitled. This immunity is jurisdictional immunity and is inviolable. The inviolability of premises, property, and assets are also involved. UNRWA's privileges and immunities are absolute, and they cannot be limited or restricted or set aside because of the conduct of hostilities. In order to address this question of Israel's obligations, we must first analyze its obligations from the angle of international public law, then has reflected in the UN Charter, then the international conventions related to the General Assembly and the Security Council's resolutions. As to the obligations of Israel, I think to start with, we need to analyze its obligations under the angle of human rights standards and the relevant conventions and resolutions of the UN General Assembly and Security Council. As far as lex specialis is concerned, these obligations must be identified in international humanitarian law and international human rights law. Without going over the facts of the preceding developments, it seems indisputable to Algeria that Israel, as a member of the United Nations, but also as an occupying power, cannot claim unlimited discretion to prohibit UN activities and ban its different organs and agencies, including UNRWA. The obligation of Israel to cooperate in good faith with the UN, as enshrined in the Charter, was recalled by the court in its order dated 20th of March 2024, indicating provisional measures, South Africa versus Israel, in which it said that Israel should take all necessary measures to ensure without delay and in close cooperation with the United Nations the provision by all workers of the UN to allow them to provide without any restriction on a large scale the basic services and humanitarian assistance urgently required. This consequence that Algeria contends which is based on the obligation to respect the erga omnes principles, notably the right to the Palestinian people to self-determination, is an obligation that falls on Israel, and it cannot prevent, hinder, or otherwise restrict in any manner the presence and activities of UNRWA in the occupied territories, including East Jerusalem. We are going to now look at the different obligations in 3 different sections pertaining to the different texts and charters. Article 2, 5, 100, 103, 104, and 105 of the UN Charter constitute the basis of Israel's obligations when it comes to the presence and activities of the UN, its organs such as UNRWA, other organizations, and third countries in the occupied Palestinian territory, including East Jerusalem. These obligations include the duty to cooperate and to facilitate their activities, as well as the duty to respect the privileges and immunities that they're entitled to, while recalling that Israel is party to the Convention on Privileges and Immunities, and that the scope of application of this convention has been explicitly extended to the occupied territory through the agreement entered into by Israel with UNRWA in 1967, as the UN Secretary General recalled in his letter of the 9th of December 2024 regarding the obligations of Israel under Article 2, Paragraph 5 of the Charter concerning UNRWA. And he said, as a member of the United Nations, Israel continues to be obliged in accordance with Article 2, Paragraph 5 of the UN Charter to provide every possible assistance in all actions that UNRWA undertakes in accordance with the relevant decisions of the main competent bodies adopted by virtue of its charter. By virtue of the Charter, including Resolution 302.4 of the General Assembly and the subsequent General Assembly resolutions renewing UNRWA's mandate. Thus, the provisions of Articles 100 and 104 of the UN Charter supplement Articles 2.5 and 105. These provisions protect what the court has called the independent action of the organization. Under Article 2.5, 100 and 104 of the UN Charter, Israel is obliged to facilitate UNRWA's operations in the occupied Palestinian territory, including East Jerusalem. I would like to come to Israel's obligations as an occupying power. One of the questions referred to the court by the General Assembly in its Resolution 79/232 concerns Israel's obligations as an occupying power, in particular to ensure and to facilitate unimpeded access to supplies that are indispensable to the survival of the civilian population in the occupied territories in accordance with international humanitarian laws and international human rights laws. The fact that international humanitarian law, both conventional and customary, applies to the Palestinian territory is indisputable. According to Article 43 of the Hague Regulation, that is the starting point to establish Israel's obligations as an occupying power and consist in ensuring and facilitating the provision of unhindered supplies that are essential to the survival of the Palestinian population and the provision of basic services, humanitarian and development assistance to the benefits of the Palestinian population. All these obligations fall on Israel, and this is of paramount importance. Algeria considers that Israel has an obligation to respect and to ensure respect of the Geneva Convention in all circumstances. And as the court pointed out, such an obligation derives not only from the conventions themselves, but from general principles of humanitarian law, of which the conventions are but the concrete expression. This fundamental expression, enshrined in Article 59 of the Fourth Geneva Convention, cannot be evaded by Israel once it has been established that the population in the occupied territory is insufficiently supplied, and this is what has been pointed out by the UN organs, and it has also been corroborated by the ICRC that states that this obligation of the occupying power to accept collective relief is unconditional. It completes the obligation that has been established under Article 55 of the same convention pertaining to provision of supplies. While Israel as an occupying power does have a certain degree of margin of appreciation in accepting and facilitating humanitarian aid, especially in the choice of humanitarian actors, it is fundamental in view of Article 59 and that it takes into account the concrete needs of the population and takes whatever operational possibilities are used in order to enable the provision of effective aid. In view of the fact that UNRWA is the main provider of such humanitarian aid, reduces significantly Israel's margin of appreciation in the fulfillment of this obligation. Mr. President, Algeria considers that Israel, as an occupying power, is obliged, as long as the situation persists, to provide humanitarian access to UNRWA and to use all necessary means to facilitate its relief activities in the occupied Palestinian territory. Algeria notes with dismay that the situation in the Palestinian territories, and in particular in Gaza, is one of the most striking failures of humanitarian failures of our generation. Each person in Gaza relies entirely on humanitarian assistance, and this vital link has been totally broken since the total blockade on aid that was imposed by the Israeli authorities on the 2nd of March of this year. The crisis is of an unprecedented nature and will lead to a significant humanitarian crisis. In addition to the violations of international humanitarian law, Israeli practices impede the presence and activities of United Nations, other international organizations, and other countries in the occupied territories. Therefore, the supply of humanitarian relief services, basic services, basic products, and the provision of essential goods to the population are no longer possible. And this is part of Israel's policy aimed at perpetuating its illegal presence in a Palestinian territory and in participating in the expulsion and forced transfer of Palestinian people from the OPT, as well as the expulsion of UNRWA. Humanitarian aid should never be used as a political bargaining chip or a weapon of war. Saving lives must never be a controversial issue. The principles of international law that have been developed over the centuries that aim at protecting civilians should not be swept aside, and impunity should not persist. My third point consists in analyzing Israel in the face of the right to self-determination of the Palestinian people. The court has asserted repeatedly that the right to self-determination represents one of the main principles of contemporary international law, and that the obligation to respect this right is erga omnes principle that all states have an interest in protecting. And the court held in its opinion of 19 July 2024 that the dependence of the West Bank, Jerusalem Est, and in particular Gaza on Israel for supply of basic goods compromises its enjoyment of fundamental rights, and in particular the right to self-determination. Algeria recalls that the resolutions adopted by the General Assembly that recognize the right of the Palestinian people to self-determination, including its right to create its own independent state, and that is set out in certain obligations for Israel, is an inalienable right for the Palestinian people. For the purposes of these proceedings, the obligation to respect the right of the Palestinian people to self-determination entails for Israel the obligation to cooperate for the benefits of Palestinians and ensure and facilitated unimpeded provision of humanitarian assistance and make sure that its development can be pursued because it is imperative. This alienable right, it is a principle of jus cogens, is perpetually denied by Israel. As a reminder, on the 18th of July 2024, on the day before this very court rendered its advisory opinion of 2024, the Knesset adopted a declaration opposing the creation of a Palestinian state, which is a declaration that once again was in blatant violation of the rights of the Palestinian people to self-determination. Mr. President, before I conclude and hand over to my colleague, I would like to underscore that in view of the violations committed by Israel Israel that we are witnessing a lack of effective reaction from the international community, despite constant appeals made by the Secretary General of the United Nations, the General Commissioner of UNRWA, humanitarian actors, and certain third states. Despite all this, we are witnessing an absence of action by the international community and a presence of a community of interest to the detriment of the Palestinian people, to their most fundamental rights, to their existence, to their fate and their future. Prohibiting UNRWA is tantamount to prohibiting the right of the Palestinian people to exist, to survive, to return to their land. Israel's ban on UNRWA is a way of destroying the present and the future of the Palestinian people. To abandon this agency is to abandon the Palestinian people and to enshrine a policy of double standards in defiance of international law, the decisions of this court, international legality, and the principles of equality and justice enshrined in the UN Charter, of which the contents, may I recall, were finalized on April 26th, 80 years ago, and today it is the 29th of April, 2025. I would now like to call on Ms. Samia Bouroubar to continue Algeria's presentation to the court. Thank you very much.
Thank you, Madam. The floor now goes to Ms. Samia Bouroubar. You have the floor, Madam. Mr. President, ladies and gentlemen, members of the court, we have chosen to devote the third part of this oral statement to the two unlawful Israeli laws of the 28th of October 2024, because these laws are the clearest manifestation in Algeria's view of the breach by Israel of its international obligations. Attacking the premises and the personnel of UNRWA and obstructing their work, having clearly proved insufficient, Israel reverted to its usual practice, that of legislating against international law. I would like to make a few comments on these two Israeli laws. I think these comments are necessary, and they will concern both the form and the substance of these laws. When it comes to the form, the titles of these laws adopted on the same day is instructive. They, in themselves, reflect their unlawful character. I would like to recall that the first is entitled Law to Cease UNRWA's Operations, and the second is entitled Law to Cease UNRWA's Operations in the Territory of the State of Israel. These titles, if you look at their wording and their spirit, immediately reveal Israel's intention to put an end to the presence and the activities of the agency established by the General Assembly of the United Nations and to extend their application throughout the occupied Palestinian territory. The other striking fact is the title of the second law, which confirms Israel's obsession to seek to occupy or indeed possibly to annex East Jerusalem, ignoring the negative findings of the court in its advisory opinions of 2004 and 2024, and in the resolutions of the Security Council and the General Assembly. The entry into force of both laws on the 30th of January 2025 shows that there is a sense of urgency felt by Israel, not that relating to the obligation to put an end to the distress of the Palestinian people, worsened by months of deprivation and when their most basic needs are unmet, but to conclude the process undertaken since the last military operation in order to bring an end to the presence and activities of the agency, which is the main organization set up by the United Nations in the aftermath of the Nakba in order to assist Palestinian refugees deprived of their land, their property, and their most elementary rights, including their right to return and to the building of a Palestinian state. To turn to the substance, the first element which enlightens us as to the non-compliance of both laws with Israel's obligations in Algeria's views is the fact of making unilaterally adopted measures prevail on international obligations which were freely accepted. These measures are contained respectively in Article 1, ordering the end of the exchange of letters of 1967, Article 2, prohibiting any Israeli authorities from any contact with the agency, and Article 3, which provides that this law does not rule out criminal prosecution against the members of staff of the agency. Now, to move to the second part of this third chapter, the legal consequences of the implementation of both laws in the occupied Palestinian territory. Application of these laws has to be examined in all three parts of the occupied Palestinian territory so as to assess the non-compliance by Israel as a member of the United Nations and as the occupying power with its obligations. First of all, in the Gaza Strip, Algeria wishes to lay particular emphasis on the humanitarian repercussions of the implementation of the Israeli laws in view of the situation of this part of the occupied territory and where UNRWA has had its headquarters. We can easily measure the effects of the ban of UNRWA, a deprivation for the Gazan population of any aid in the form of basic supplies and basic services. On the 8th of April, according to UNRWA's report, Israeli civil servants from the Education Department from the municipality of Jerusalem, accompanied by Israeli forces, forcefully entered into 6 schools run by the agency, bearing orders for their closure, which will come into effect in the following 30 days, that is, on the 8th of May. These closures, which will lead to the deprivation of schooling for 800 pupils, amounts to a breach by Israel of its obligations to respect the inviolability of the premises of international organizations. In the West Bank, the effects of these laws will mainly affect the right to education and the right to health. In Algeria's views, these 2 Israeli laws, which are ipso facto void, cannot unilaterally put an end to Israel's obligations as they result from the exchange of letters of 1967. In the note verbal of the 8th of January 2025, addressed by the Secretary General of the United Nations, I quote, Israel remains bound to grant UNRWA all the privileges, immunities, and facilities provided for in the General Convention and confirmed in the exchange of letters, as long as UNRWA operates in the occupied Palestinian territory, including East Jerusalem. To turn to the fourth part of my presentation, I would like to briefly describe the breaches by Israel of its obligations and the implementation of its international responsibility. It should be specified that these breaches can be grouped into 3 categories. First of all, breaches of the obligation to provide basic supplies and basic services. Algeria would like to recall the various Israeli breaches, including the decision taken on the 2nd of March of this year, and with the ceasefire being in force, of suspending the entry of any goods or supplies into the Gaza Strip, thus depriving it of food, drinking water, shelters, and medical care. Now, if we look at the violations of the obligation to provide humanitarian aid and aid to development, because of the restrictions imposed by Israel, which have been described, and which resulted in a spectacular drop in humanitarian aid, through a number of resolutions, including Resolution 2730 of 2024, the Security Council emphasized these breaches with regard to the aid to development. It goes without saying that in Algeria's views, the impediments created by Israel to the provision of basic supplies and the delivery of humanitarian aid have seriously contributed to the deterioration of the social and economic situation of the Palestinian people, which was already precarious. The declaration of the UNPD administrator summarizes the impoverishment of the Palestinian population. I quote, "The projections of this new assessment confirm that in the midst of the immediate suffering and terrible loss of human lives, a serious development crisis is taking place, a crisis which jeopardizes the future of Palestinians for generations to come," unquote. There is no need, in Algeria's view, to add anything more. I now turn to the breaches of the right of the Palestinian people to self-determination, a well-established law and which has already been discussed. I would merely like to state that the breaches by Israel of its obligations with regard to the presence and activities of the United Nations and all of its organizations jeopardize this absolute right. All roads may lead to Rome, but there is only one road which should lead the Palestinian people to its dignity, and that is its right to self-determination. I now turn to the international responsibility of Israel in the view of its breaches. This responsibility is based on the articles of the International Law Commission on international responsibility of the state for internationally wrongful acts, and which are attributable to Israel because of the various breaches it has committed. And I would merely like to refer to the international responsibility of Israel, which arises pursuant to Article 41 with regard to the serious breach of the rule of jus cogens, which is the right to the Palestinian people to self-determination. To conclude, Algeria reiterates the requests it has expressed in its written submissions and asks the court to declare that Israel is in breach of its legal obligations as a member of the UN with regard to the organization and as an occupying power. Mr. President, members of the court, I thank you for your attention.
Je remercie les représentants de l'Algérie pour leur présentation. I now invite the delegation of Saudi Arabia to make its oral statement, and I call upon Mr. Mohammed Saud Al Nassal to take the floor. You have the floor, sir.
Mr. President, distinguished members of the court, it's an honor for me to appear before you to present my country's views on a matter of a critical importance for the United Nations, all states, and in particular for the Palestinian people. Mr. President, on behalf of my country, the Kingdom of Saudi Arabia, I would like first to congratulate you on assuming the presidency of this court. Mr. President, distinguished members of the court, less than a year ago, the court held that Israel's policies and practices in the occupied Palestinian territory, including its settlement practice, its continuing occupation, and its annexation of parts of that territory are flagrant violations of international law that must be brought to an end as a matter of urgency. The court's ruling marked a clear path for Israel to follow in finally bringing itself into international legality. Sadly, but predictably, Israel chose to ignore the court's ruling, showing that it considered itself above the law. Outrage over Israel's conduct, particularly since October 2023, has compelled the UN General Assembly to return to the court to seek its guidance on another pressing matter. This time, the question placed before the court and the circumstances which have brought it about are of more immediate and extreme importance. Those circumstances include the General Assembly's alarm over the impunity with which Israel has continuously blockaded the provision of humanitarian, life-saving, and other desperately needed assistance by the UN and other concerned parties to the Palestinian population throughout the occupied Palestinian territory, most egregiously in the Gaza Strip. Confirming the obligations of Israel to allow the United Nations, other international organizations, and third states to carry out activities in the occupied Palestinian territory, including providing such assistance, could truly make the difference between life and death for many people. Israel's hideous conduct, which piles illegality upon illegality, is well documented. Its most ruthless application has been the siege conditions imposed over the Gaza Strip since October 2023. As the entire world is painfully aware, diseases, lack of sanitation, clean water, food, shelter, and medical care is endemic. While temporary respites have occasionally occurred, Israel has reimposed conditions of total blockade at will, just as it did in early March this year, completely halting the provision of food, water, medical supplies, temporary housing, fuel, and anything else to the starving, displaced, and exposed population of the Gaza Strip. Nothing justifies such barbarity. Israel's blockade of humanitarian assistance and simultaneous brutalization of the civilian population throughout bombardment can only be understood as two components of a single enterprise, namely a means for bringing about the ethnic cleansing of the Gaza Strip, displacing or killing its Palestinian population to make room for Israel to settle and annex the territory. Israel's failure to ensure and facilitate unhindered humanitarian assistance to the population of Gaza would surely be seen as an integral part of this crime against humanity, if it were ever to come to pass. And of course, withholding such a humanitarian development assistance also plays a role in a larger Israeli undertaking, that is, to demolish the established right of the Palestinian people to self-determination by undermining their ability to survive and stand on their own. The court is aware of the appalling circumstances faced by the population of the Gaza Strip and their dire need for humanitarian assistance on a sustained basis. The court has issued provisional measures in South Africa versus Israel on 3 occasions, ordering Israel to take all necessary and effective measures to ensure the provision of desperately needed humanitarian assistance to Palestinians throughout Gaza. Israel ignored those orders, as it has similar calls made by other UN bodies, international organizations, and concerned states. Instead, it has exacerbated the humanitarian crisis and turned the Gaza Strip into an unlivable pile of rubble, while killing thousands of innocent and vulnerable people. Mr. President, distinguished members of the court, on or around April 15th of this year, the Palestinian death toll in the Gaza Strip reached a grim figure of 51,000, some 15,000 of them children. Over 116,000 people have been wounded. These figures increase every day, even during the short periods of so-called ceasefire. It's not difficult to understand why, as the Israeli military has removed all restraints on killing innocents. It has conducted over 40,000 airstrikes on the tiny strip. Terrifyingly, it employs artificial intelligence to determine who to kill and who to spare. Establishes kill zones where anyone crossing invisible boundaries, even women and children, is shot on sight. Bombards so-called safe zones, killing countless innocents, many while sheltering in flimsy tents, and denies requests by international organizations to import equipment required to clear the estimated thousands of unexploded Israeli ordnance scattered across the Gaza Strip, which have killed or maimed numerous innocent Palestinians. Adding to these catastrophic conditions has been the systematic destruction of hospitals, water infrastructure, agricultural land, bakeries, homes, and other vestiges of life throughout the territory, creating conditions of suffering, disease, and starvation. The request now before the court seeking to clarify the obligations of Israel to allow international organizations and states to provide humanitarian assistance and operate within the occupied Palestinian territory, including Gaza, must be seen in this context, as it explains why the request has such urgency and importance. As shameful as Israel's conduct towards the Palestinian people is, the harm it caused them not the only damaging consequences of that conduct, nor the only reason why the question before the court has such importance. Another critical reason to establish the scope of the Israeli obligations encompassed by the General Assembly's request is to clarify the legal framework for evaluating Israel's actions against the UN and other international organizations and third states seeking to assist the Palestinians within the occupied Palestinian territory. Israel's hostility towards the UN is too lengthy to summarize here. Its attacks have been particularly aimed at UNRWA, which since 1949 has played an indispensable role in safeguarding the basic rights and living conditions of the Palestinian people who were displaced from their homeland, providing health care, education, food, and other assistance to some 5 million refugees. As emphasized by the UN Secretary General, when it comes to providing humanitarian relief and assistance to the people of Gaza, there is no realistic alternative to UNRWA. Israel's hostility against UNRWA began long before the current crisis. However, since October 2023, its attacks have intensified dramatically. Israeli forces have killed over 200 UNRWA employees, attacked and destroyed their premises, ransacked their warehouses, and denied entry to UNRWA relief supplies. Israeli police have stood by while UNRWA's premises in Jerusalem were attacked and burned by an Israeli mob. Israel also ordered UNRWA to vacate its premises in occupied East Jerusalem and has passed laws prohibiting Israeli authorities from having any contact with UNRWA and preventing UNRWA from operating within Israeli territory, which it illegally claims includes occupied East Jerusalem. The excuses Israel has given to justify its actions, claiming that UNRWA lacks neutrality, promotes biased narratives, and is infiltrated by Hamas, have been addressed by the UN and discredited. Moreover, an independent review led by the former French foreign minister found Israel's allegation to be unsubstantiated and lacking of any credible evidence. The fabrications underlying Israel's action against UNRWA and against the UN more generally cannot be seriously doubted. What those actions establish, however, is the court's opinion about Israel's obligation encompassed with the General Assembly's request is urgently required, not just to prevent further harming the Palestinian people's right to receive humanitarian development support, but also to safeguard the legal foundation in which the UN and other entities conduct humanitarian activities. Turning to the court's jurisdiction, our views and the views of almost every other state participating in these proceedings are in agreement that, given the legal questions raised, The court has jurisdiction to issue the requested advisory opinion, and that there are no compelling reason for it not to do so. On the contrary, given the inhumane conditions to which Israel has subjected to the Palestinian people, most terrifyingly in the Gaza Strip, we respectfully submit that the court is under a duty to issue its opinion so that Israel's obligation to ensure and facilitate the provision of humanitarian assistance by the United Nations, other international organizations, and third states are made clear. Furthermore, the General Assembly's inquiry on Israel's obligation impact matters of widespread importance, including the operations of the UN and other aid agencies, as well as Palestinian rights, a matter of universal concern since the adoption of Resolution 181 in the second session in 1947. The requests also highlight urgent issues, including Israel's legislative ban on UNRWA, military actions impeding humanitarian aid, and threats to the UN privileges and immunity. A small minority of a group and states argue that the court should refrain from issuing this advisory opinion because doing so would require it to undertake a significant factual investigation, which is not appropriate for an advisory opinion, or that the question was formulated in a biased manner. These arguments, which were rejected by the court in the Wall and the Israeli policies and practices cases, would be similarly dismissed for the same reasons articulated in those decisions. The same states argue that the court should decline to give this opinion because it has already addressed the subject of the request in its previous advisory opinions related to the occupied Palestinian territory, or that rendering the occupied would prejudge the ongoing contentious proceedings in South Africa versus Israel. These arguments have no merit. The present request is self-evidently distinct from the prior requests, as the scope and nature of Israel's obligations to ensure and facilitate the provision of humanitarian assistance by the UN, other international organizations, and third states was not expressly addressed by the court in either of those advisory opinions, leaving the court views in that regard unknown. As for the argument that these advisory proceedings would prejudge the outcome of the genocide case, that argument fails for obvious reasons. As for the argument, these advisory proceedings would prejudge. In South Africa versus Israel, the court is called upon to interpret and apply the Genocide Convention and to determine whether Israel's conduct in Gaza engage its international responsibility under that convention. To a significant extent, the answer to that question is whether the requisite intent under Article 2 of the convention can be attributed to Israel. The answer to the questions raised in these proceedings, which are broadly focused on identifying the obligation of Israel to ensure and facilitate humanitarian and other assistance throughout the occupied Palestinian territory, and do not ask the court to determine Israel's responsibility under the Genocide Convention, and would in no way prejudge that narrow question. Turning to the question before the court, I will highlight only a few key points. First, as an occupying power, Israel is bound by international humanitarian law, in particular, the Hague Regulations of 1907 and the Fourth Geneva Convention. Under those norms, and at the bare minimum, Israel must guarantee the basic needs of the population in the occupied Palestinian territory at all times, including the provision of food, water, shelter, and medical supplies. It must allow medical personnel to carry out their duties and must not adopt measures amounting to collective punishment. But Israel's obligations do not end there. Pursuant to Article 59 of the Fourth Geneva Convention, If an occupying power is unwilling or unable to fulfill its duty to provide the whole or part of the population of the occupied territory with essential supplies and services, as obviously the case in Gaza, it has an absolute duty to facilitate such provision by international organizations or third states. These obligations are unconditional and are supplemented by Article 69 of Additional Protocol 1. These obligations are, in the case of Israel, complemented by the duty of raising under Security Council resolutions not to obstruct, attack, or impede organizations and states from providing urgently needed humanitarian development assistance to the population in the occupied Palestinian territory. As an occupying power, Israel's international human rights law obligations are also engaged. Under these obligations, Israel must respect, protect, and fulfill the fundamental human rights of the Palestinian people in the occupied Palestinian territory. These include their right to life, to the highest attainable standard of physical and mental health, to an adequate standard of living, to adequate food, clothing, housing, water, and education. The obstruction by Israel of efforts by international organizations, including the United Nations, or by third states to provide basic services and assistance to the Palestinian people under occupation in order for them to enjoy such protected human rights entails a clear violation of Israel's human rights obligations. As a UN member and as a party of the UN Convention on Privileges and Immunities, Israel has further obligations relevant to these advisory proceedings. Under Article 2, subsection 2 and 2, subsection 5 of the UN Charter, Israel must cooperate in good faith with the United Nations, giving it, quote, every assistance in any action taken in accordance with the Charter, end quote. Israel's obligation to provide every assistance in good faith to the United Nations encompasses the principal UN organs as well as other UN subsidiary organs, including UNRWA. As UNRWA's mandate is to provide humanitarian assistance to the Palestinian people, Israel duty-bound to give every assistance to UNRWA in good faith. The attempt by certain states in these proceedings to limit Article 2, subsection 5 as only applying to enforcement action by the Security Council pursuant to Chapter 7 of the Charter is incorrect and contrary to this court's interpretation of that provision in the Reparations Advisory Opinion. Under Article 25 of the Charter, Israel has also agreed to accept and carry out the decisions of the Security Council. Israel must therefore comply with the Security Council resolution demanding that it give unhindered access to those providing humanitarian assistance to the Palestinian people. Israel also has a duty to guarantee that the UN enjoys the legal capacity necessary for exercise of its functions and fulfillment of its purposes. This duty is enshrined in Article 104 of the Charter and Article 1, Section 1 of the Convention on Privileges and Immunities. Moreover, Israel is under a duty to guarantee the United Nations and its officials the privileges and immunities necessary for the fulfillment of their functions. The obligation is contained in Article 105, subsection 1 of the Charter and was further developed in the Convention on Privileges and Immunities. That convention provides that the United Nations, as well as its officials, property, and assets are immune from every form of legal process. Recently enacted Israeli laws that target UNRWA by revoking its privileges and immunities and allowing potential criminal proceedings against UNRWA. Officials breach these duties Finally, the Convention states the undisputed principle that the premises of the United Nations shall be inviolable. This obligation has several implications. First, Israeli authorities may not enter the premises of the United Nations or its organs without their consent. Second, Israel has a positive duty to protect and safeguard those premises from external threats. And third, Israel must not attack those premises. Importantly, these obligations are not qualified and do not cease to apply in situations of armed conflict. Thus, Israel's failure to guarantee the inviolability of UN premises can never be justified on grounds of military expediency or national security. I now turn to Israel's obligation to respect the Palestinian people's established right to self-determination. I use Coggan's norm, generating obligations erga omnes. If that obligation is to mean anything, it surely requires, at a minimum, that Israel allow the provision of humanitarian development assistance to the Palestinian people by those prepared to give it so as to strengthen their ability to achieve self-determination. Israel's refusal to comply with that imperative while perpetrating unspeakable violence on the Palestinian people can only confirm the worst fears about its intentions. The court's voice confirming the scope and nature of Israel's obligations to ensure and facilitate humanitarian development assistance to the Palestinian population will serve as powerful force in preventing those fears from becoming a reality. In closing, the Kingdom of Saudi Arabia wishes to emphasize that the Palestinian people's right to self-determination is at the core of the question before the court. The Kingdom takes this opportunity to reaffirm its unconditional commitment to the establishment of an independent and sovereign Palestinian state with the 1967 borders with East Jerusalem as its capital. This unwavering position is non-negotiable and is not subject to compromises. Mr. President, distinguished members of the court, thank you for your attention. This concludes the statement of the Kingdom of Saudi Arabia.
I thank the representative of Saudi Arabia for his presentation. Before I invite the next delegation to take the floor, the court will observe a coffee break of 15 minutes. The hearing is suspended.
La Cour.
Please be seated. The sitting is resumed. J'invite à présent
I would like to invite the next presentation from the delegation of Belgium. I would like to call Mr. Antoine Misson to take the floor. Mr. President, honorable members of the court, it is indeed a great honor for me to appear before you as the agent of the Kingdom of Belgium in these proceedings for the request of an advisory opinion from the court, a request that was made by the UN General Assembly in its resolution of 19th of December 2024. As Belgium has had the occasion to emphasize, and I would like to quote, respect for international law, including international humanitarian law and human rights law, is a cornerstone of peace and security. End of quote. The current conflict in Gaza has put and continues to put international law to the test. And it is precisely at times like this that it is essential to reaffirm unequivocally our support for the international norms that ensure peaceful coexistence within the international community. In view of the time available to Belgium, Belgium will elaborate on some of its written submissions in the light of arguments invoked by the previous speakers. As to the other aspects of the question, Belgium respectfully refers the court to the detailed analysis in its own written submissions. With your permission, I will first briefly address the question of your court's discretionary power. Then I will focus on Israel's obligations as member of the United Nations organization. Professor Vayos Koutroulis will then examine Israel's obligations with regard to the provision of humanitarian assistance. Mr. President, in order to comply with international law, it is necessary to know the scope of its rules. And according to the court's established jurisprudence, when the court is called upon to give an advisory opinion, it should not refuse to respond to the request unless there are compelling reasons to do so. However, no arguments that could lead the court to refuse to give an advisory opinion in this case have been put forward in the written procedure and by the participants to these proceedings. In fact, the majority of them have rejected these arguments that were already invoked before the court previously in previous advisory proceedings. Furthermore, if no arguments invoked constitute compelling reasons justifying the use of its discretionary power by the court, it is obvious that cumulatively these arguments should not alter that decision either. In fact, the present procedure will help the General Assembly in fulfilling its role and its functions. It is necessary because the two previous advisory opinions rendered by the court on the same general situation have not been implemented. It is therefore difficult to say the least, that in these current proceedings, any weaponization or misuse of the procedure is not possible. On the contrary, the court is called upon to state the law so that all parties concerned may act accordingly. Belgium thus invites the court to recognize that there is no compelling reason that justifies not responding to the General Assembly's request for an advisory opinion. I would now like to come to the second part of my presentation on the obligations of Israel as a member of the United Nations. As a member, every member of the United Nations has certain obligations towards the organization, its organs and its staff under the UN Charter. Furthermore, other conventions, such as the 1946 Convention on Privileges and Immunities, also contain additional obligations applicable to Israel. And in this context, respect for international law implies cooperating with the UN and assisting the UN in its action by avoiding any unilateral action. First of all, Article 2, Paragraph 5 of the Charter provides that all UN members, and I quote, shall give the United Nations every assistance in any action it takes in accordance with the present Charter. End of quote. As is clear from this wording, this obligation applies to any action undertaken by the UN and any of its organs. Therefore, it is not limited to the Security Council's decisions adopted under Chapter 7 of the Charter, but it also covers the presence and the activities of organs such as the UN Relief and Works Agency for Palestinian Refugees in the Near East, the UNRWA. Obviously, the deployment of the UN and its staff on the territory requires consent of the state. However, it only concerns the territory on which a state exercises its sovereignty. However, as the court has confirmed in its advisory opinion of the 19th of June 2024, and I quote, Israel is not entitled to sovereignty over or to exercise sovereign powers in any part of the occupied Palestinian territory on account of its occupation. It follows that Israel cannot make the presence of the activities of the UN and its organs and the UN agencies and UN staff on Palestinian occupied territory subject to its consent. The obligation, therefore, to cooperate and assist any UN action can thus take its full effect with regard to the activities of the UN, including UNRWA, on the occupied Palestinian territory. The measures taken unilaterally against UNRWA are based, among others, on allegations of violations of neutrality by members of its staff. These allegations are extremely serious and must obviously be taken seriously. Indeed, the United Nations has not remained inactive in the face of these allegations. Like other participants in these proceedings, Belgium highlights the investigations conducted by the Office of Internal Oversight Services, which led to the dismissal of individuals against whom there was evidence indicating that they may have been involved in the attacks of 7th of October 2023. In addition, the UN requested an independent assessment of the mechanisms and procedures for ensuring UNRWA's compliance with the principle of neutrality. The report issued in this context tests, among other things, that UNRWA has examined all external allegations of breaches of neutrality and that it has opened investigations in cases where there was prima facie evidence of misconduct. Furthermore, the report indicates that Israel has not provided evidence to support its allegations that a significant number of UNRWA employees are members of terrorist organizations. Thus, we are Far from the picture painted by Israel in the Security Council that, and I quote, UNRWA has been proven to be an instrumental part of Hamas's terrorist machine, which makes UNRWA itself a terrorist organization, and that, I quote, in Gaza, Hamas is the United Nations and the United Nations is Hamas. End of quote. Belgium rejects such characterizations and therefore considers that in this context, the Security Council resolutions on terrorism are relevant. In view of the foregoing, the unilateral actions taken against the United Nations and more specifically against UNRWA are not only unjustified, but also a violation of the obligations assumed by member states of the United Nations. Problems and grievances relating to the actions of its personnel must be resolved with the UN organization and not against it. This concludes the second point of Belgium's oral statement. Mr. President, I now invite Professor Vayos Koutroulis to continue the presentation of Belgium's observations. Thank you for your attention.
Je remercie Monsieur Misson.
Thank you to Mr. Missoun. I now give the floor to Professor Vayos Koutroulis. You have the floor, sir. Mr. President, honourable members of the court, it is a great honour for me to appear before you again on behalf of the Kingdom of Belgium. I shall continue with the oral statement of Belgium by addressing the obligations of Israel in relation to the supply of humanitarian aid. With the resumption of hostilities, Israel has once again blocked, on the 2nd of March of 2025, blocked the entry of humanitarian aid to Gaza. The updates on the humanitarian situation in Gaza, published at the beginning of April 2025 by the Office for the Coordination of Humanitarian Affairs of the United Nations, in particular, state that medicines are rapidly becoming depleted. The majority of humanitarian assistance movements and missions coordinated with the Israeli authorities have been refused. Gaza is once again faced with the risk of famine and malnutrition. Access to water remains very limited and very unequal, and the sanitation conditions remain alarming and are likely to worsen public health hazards. It is therefore necessary and urgent to recall the obligations of Israel relating to the provision of humanitarian aid and to clarify its contents, bearing in mind that these obligations must be interpreted and applied in good faith. To begin with, I would like to dwell on the content of the obligations stemming from international humanitarian law specifically. I will then stress the absence of reasons which might justify the violation of these obligations. Mr. President, Israel's obligations to supply humanitarian aid stem not only from international humanitarian law, but also, in particular, from international human rights law, the right to self-determination, relevant resolutions of the United Nations, and the relevant provisional measures ordered by the court in the case opposing South Africa to Israel. This legal framework imposes on the occupying power negative as well as positive obligations. At the beginning of April 2025, the number of humanitarian workers killed since October 2023 was in excess of 400. we unfortunately have no choice but to recall that it is prohibited to attack paramedics and humanitarian workers, especially when they're traveling in vehicles with the appropriate markings and with their lights flashing. Concerning humanitarian law, more particularly, and pursuant to Article 55 of the Fourth Geneva Convention of 1941, as the occupying power, Israel holds the main obligation for providing humanitarian assistance to the population of the occupied territory, I quote, to the fullest extent of the means available to it, unquote. And when, in spite of this obligation, the civilian population is inadequately supplied, Article 59 of the same convention provides, I quote, that the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by all the means at its disposal, unquote. The terms inadequately supplied must be interpreted in good faith in the light of the other rules of applicable international law, including those stemming from international human rights law. For instance, pursuing to Article 43 of the Hague Regulations of 1907, the occupying power holds the general obligation of administering the occupied territory and ensuring, I quote, public life and order, unquote. In Articles 11 and 12, the International Covenant on Economic, Social and Cultural Rights, these articles provide for the right to water and the right to a sufficient standard of living for each person and their family, including sufficient food, clothing, and housing. The Committee on Economic, Social and Cultural Rights has explained that the right to sufficient food laid down in Article 11 of the Covenant, I quote, shall not be interpreted in a narrow or restrictive sense, which equates it with a minimum package of calories, proteins, and other specific nutrients, unquote. And the same committee has held, I quote again, that the notion of an adequate water supply must be interpreted in a way compatible with human dignity and not in a narrow sense by merely referring to quantity criteria. It follows that the occupying power does not only hold an obligation to keep the civilian population alive. After all, in an occupied territory, the occupying power must ensure public order and life, and not merely the life of civilians. Thus, in order for the civilian population to be considered as inadequately supplied, it doesn't need to be on the verge of famine or see its survival threatened. In the instant case, there is no doubt that the civilian population in the Gaza Strip is inadequately supplied. Consequently, Israel must accept and facilitate relief efforts from impartial international organizations, third states, and humanitarian organizations. After these brief remarks on the content of the obligations of the occupying power under humanitarian law, I will address the absence of reasons which might justify the breach of these obligations, and this will be the last point raised by Belgium. Mr. President, complying with obligations relating to the provision of humanitarian aid and applying them reasonably includes not seeking to escape them by invoking justifications which are not admitted in international law. In this case, it is military and security interests which have been invoked in order to justify behavior non-compliant with the obligations of international humanitarian law. And in connection with this justification, Belgium wishes to emphasize 3 points. Firstly, insofar as the military and security interests refer to the lawfulness or the legitimacy of the use of force, Belgium recalls that such considerations cannot affect neither the applicability of the rules of humanitarian law nor the way in which these rules are interpreted and applied to the belligerent parties. This is what the principle of equality of belligerents provides as a cardinal principle of humanitarian law, based, amongst others, on Article 1, which is common to all the Geneva Conventions. Secondly, although the argument refers to military necessities, these necessities are already taken into account in the drawing up of any rule of humanitarian law, and they cannot therefore be invoked a second time in order to justify the breaches of this law. Furthermore, Article 43 of the Hague Regulations, which allegedly is the source of a general excuse in favor of the military necessities of the occupying power, in reality says nothing of the sort. The article provides in particular, I quote, that the occupying power shall take all measures dependent on it with a view to re-establishing and to assure, as far as possible, public order and life, unquote. This provision contains no explicit reference to military interests. On the contrary, emphasis is clearly laid on the obligation for the occupying power to take all measures possible to ensure public order and life. Article 43 of the Hague Regulations cannot, therefore, serve as the basis for a general excuse linked to military necessities, and certainly not in order to justify the breach of obligations stemming from another convention, the Fourth Geneva Convention. These obligations are not conditional on Article 43 of the Hague Regulations. Thirdly, and to conclude, the military interests of the occupying power are obviously not overlooked by humanitarian law. On the contrary, they are taken into account in any rule of this law. Therefore, military interests cannot be invoked, or only insofar as the relevant provisions allow for this. If a rule lays down an unconditional obligation, the occupying power cannot invoke its military interests to refuse to comply with it. If the formulation of a provision allows account to be taken of the military interests of the occupying power, invoking them is not problematic as long as it remains within the limits provided for by the relevant rule. This interpretation must always be made in good faith. And thus, for instance, imposing procedures or conditions of access so very stringent that they make the delivery of humanitarian aid impossible or impractical is tantamount to refusing access to humanitarian aid and cannot be justified by military considerations. Mr. President, several speakers have proved sensitive to the military and security interests of Israel. Throughout its presentation, Belgium has chosen to insist on the respect for international law to underline an idea which is as simple as it is essential. The military and security interests of a state must be exercised in compliance with international law and not in spite of international law. Mr. President, honourable members of the court, this concludes the oral statement of the Kingdom of Belgium. I thank you for your kind attention. I would like to thank the representatives of Belgium for their presentations.
The delegation of Colombia to make its oral statement, and I call His Excellency Mauricio Jaramillo to the podium. You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the court, it is an honor to appear before you today on behalf of the Republic of Colombia. Colombia stands before this court to express its grave concern over the dire humanitarian situation in the occupied Palestinian territory, a situation caused by Israel and further exacerbated by its own plans and measures that interfere with the United Nations' presence and operations in the field. This concern, broadly shared by the international community, has led the General Assembly to seek urgent guidance from the court through these expediting proceedings. In line with its consistent commitment to full realization of the inalienable right of the Palestinian people to self-determination, Colombia actively supported and promptly sponsored Resolution 79-232 of 19 December 2024. Our presence here is also a reaffirmation of Colombia's long-standing tradition of respect for international law. Furthermore, Colombia is before you today in compliance with the duty incumbent upon all states, as the court has reaffirmed, to ensure that any impediment to the exercise of the Palestinian people of its right to self-determination resulting from the illegal presence of Israel in the occupied Palestinian territory is brought to an end. Colombia thus categorically rejects any recourse to violence or unilateral act that leads to a higher level of confrontation and expresses its particular alarm for the deteriorating humanitarian situation in the Gaza Strip, where after months of continuing siege and ongoing attacks on civilians and infrastructure, hostilities have intensified even as these proceedings are conducted. Colombia contends that Israel has engaged in escalating conducts which have put the Palestinian population in an impossible position, on top of a dire humanitarian crisis that Israel itself has created. Israel has now placed serious impediments for international organizations as well as third states to fulfill their respective mandates and obligations under international law. Israel has made the Palestinian population subject exclusively to its power and has impeded the work of relief agencies, which have been the only protection for the starving population, a population already facing the threat of constant war and destruction, and depriving it of the lone source of food, health, or education. Colombia submits that such conduct is inconsistent with Israel's status as occupying power, unlawful as the occupation itself is, and constitute a breach of its obligation as member of the United Nations and under international humanitarian and human rights law. Against this background, I shall first refer to Colombia's views on the jurisdiction and discretion of the court. Thereafter, I will refer to Israel's obligation arising both from its status as a member of the United Nations and under international humanitarian law, as well as the legal consequences entailed from its international wrongful acts. Finally, I will conclude this statement by setting out a series of final observations. Mr. President, a handful of states have urged the court to exercise its discretion to refrain from issuing the requested opinion, contending that it might affect or prejudge determinations to be made in the contentious proceedings initiated by South Africa against Israel. Colombia firmly rejects this reasoning. Advisory proceedings should never be used to bring to the court matters that are essentially bilateral. Nonetheless, in the present proceedings, the question refers to a wide range of issues that are of general concern. This is confirmed by the fact that an overwhelming number of member states decided it was fundamental for the General Assembly to receive guidance on the question put to the court. The General Assembly, moreover, was emphatic in expressing the view that developments on the ground, particularly those which could prevent UNRWA and other agencies, as well as third states, from continuing its essential work in the occupied Palestinian territory, demand consideration and guidance from the court on a priority basis and with the utmost urgency. The General Assembly is therefore in acute need of this guidance. Colombia will now focus on three topics which, in our view, could serve as guidance to the court in addressing the question posed by the General Assembly. First, the centrality of the right of the Palestinian people to self-determination and Israel's corresponding obligation to bring the occupation to an end. Second, Israel's responsibilities arising from its status as a member state of the United Nations and under international humanitarian law. Finally, the legal consequences entailed by Israel's international wrongful acts. Mr. President, distinguished members of the court, General Assembly Resolution 79-232 takes at its point of departure and point of arrival the inalienable right of all peoples to self-determination, hence recognizing it as one of the essential principles guiding the obligations under the relevant rules of international law applicable that shall also guide the activities of Israel as the occupying power in the occupied Palestinian territory with regard to the right of the Palestinian people. In this vein, Colombia recalls that, as mentioned by the court in the legal consequences advisory opinion, Israel as the occupying power has the obligation not to impede the Palestinian people from exercising its right to self-determination, including its right to an independent and sovereign state over the entirety of the occupied Palestinian territory. The centrality of the right to self-determination as, I quote, one of the essential principles of contemporary international law is enshrined in the Charter of the United Nations and is recognized as a rule of customary international law vested with the status of jus cogens norm. This court has further recognized that the obligation to respect the right to self-determination is an erga omnes obligation, thus implying that all states have a legal interest in ensuring its protection. It follows that a paramount and corresponding obligation incumbent upon Israel, given its prolonged and unlawful presence in the occupied Palestinian territory, is to bring its occupation to an end as rapidly as possible, as consistently pointed out by relevant United Nations organs. With this framework in mind, we turn now to Colombia's second point, namely that of Israel's responsibilities arising from its status as a member state of the United Nations and under international humanitarian law with respect to the presence and operations of the United Nations, its agencies, other organizations, and even third states in and concerning the occupied Palestinian territory. The Republic of Colombia is of the view that Israel, as a member of the United States, is subject to two core obligations. First, to fulfill in good faith the obligation it has undertaken under and in accordance with the Charter of the United Nations, and second, to assist the United Nations in any action it takes pursuant the Charter. With regard to the first obligation, Article 2, Paragraph 2 of the Charter, require Israel to fulfill in good faith the obligations it accepted when it ratified this treaty, which in any event prevail over any other obligation according to Article 103. In line with the general obligation, Section 34 of the General Convention of the Privileges and Immunities of the United Nations of 1949 provides that, I quote, when an instrument of accession is deposited on behalf of any member, the member will be in a position under its own law to give effect to the terms of this convention. Therefore, Israel, as a state party to this convention since 1949, is bound by the obligations contained therein and must fulfill them in good faith with regard to the United Nations, including UNRWA, an agency of the organization. Regarding the second obligation, Article 2, Paragraph 5 of the Charter, which refers to the obligation of assistance owed to the organization by all member states, it constitutes an essential element to allow the United Nations to fulfill its purposes and principles. The terminology employed in this provision is unambiguous, and it establishes a broad obligation encompassing every assistance in any action undertaken by the United Nations. The above extends to agencies and bodies of the organizations established under Article 22 of the Charter, such as UNRWA, whose mandate is to implement resolutions issued by the General Assembly, thus constituting actions taken by the United Nations in accordance with the Charter. Therefore, Colombia considers that as a member of the United Nations, Israel is required to give UNRWA every assistance in any action it takes in accordance with the Charter, including by fulfilling its obligations under the General Convention and the exchange of letters in relations with UNRWA. Colombia shares the view of several states which in their written statements expressed that Israel must comply with the obligation encompassed in the condition of its admission to membership in the United Nations, as contained in General Assembly Resolution 273 of 1949. In this regard, to honor the commitment undertaken upon its admission to the United Nations, the State of Israel is obliged to fully and faithfully comply with the provisions of the Charter in relation to the presence and activities of the United Nations. This entails, inter alia, bring an end to the occupation, cease all violations of the Palestinian people's right to self-determination, uphold the privileges and immunities of United Nations property and personnel, refrain from any interference with the delivery of humanitarian assistance, whether rendered by UNRWA, other agencies or organizations, or third states, and more broadly, conduct itself as a peace-loving state in accordance with the principles of international law, and particularly of international humanitarian law, as it will be further elaborated below. Mesdames et Messieurs les membres de la Cour,
Ladies and gentlemen of the court, Israel's status as the occupying power over the whole of the occupied Palestinian territory has been confirmed by the court due to the effective control it has exercised over that territory since at least 1967. Accordingly, Israel has since been under an obligation to comply with applicable international humanitarian law, including the Fourth Geneva Convention, the 1907 Hague Regulations, and relevant customary rules of international humanitarian law. The current humanitarian situation makes it even more imperative for Israel to honor its legal obligations. And I will now present a series of considerations relating to the specific obligations that Israel, as the occupying power, must observe in accordance with international humanitarian law, particularly with regard to the presence and activities of the United Nations in the occupied Palestinian territory. Firstly, as indicated in its written statement, Colombia stresses that the provision of humanitarian assistance and basic services to the civilian population of the occupied Palestinian territory is essential to guaranteeing its protection and subsistence. As the occupying power, Israel is responsible for the administration of the territory and is therefore required to act for the benefit of the civilian population residing there. Consequently, Israel is bound by several rules governing humanitarian aid in the context of occupation. First, in the context of an international armed conflict, Article 23 of the Fourth Geneva Convention imposes a general obligation on Israel to allow free passage to humanitarian consignments intended for civilians. Secondly, under customary international law, Israel, as the occupying power, must ensure that all items and supplies needed for the survival of the civilian population be available. In addition, under Article 59 of the Fourth Geneva Convention, Israel is required to agree on behalf of the civilian population to relief schemes, which may be undertaken either by third states or by impartial humanitarian organizations when the needs of the population are not met. Colombia notes that throughout these proceedings, several states have underscored that Israel's failure to meet the needs of the civilian population constitutes a violation of international humanitarian law. Similarly, Colombia contends that Israel cannot simply disregard its duty to allow the free passage of humanitarian consignments by relying on its own presumptions. To be exempted from its obligations, Israel must provide concrete evidence that the needs of the civilian population are sufficiently met. Colombia considers that this is not the case, as Israel cannot deny the vital role played by UNRWA. As a result, the vast majority of participants in these proceedings have demonstrated that no other body has the infrastructure, capacity, and experience to carry out the specific mandates entrusted to UNRWA. Colombia therefore considers that Israel is in breach of its obligation under international humanitarian law to refrain from any action that impedes the provision of basic services and humanitarian aid to the Palestinian population. Mr. President, members of the court, Israel must refrain from attacking, destroying, removing, or rendering useless goods and assets that are essential to the survival of the civilian population. Colombia maintains that Israel, as the occupying power, must refrain from targeting medical facilities, medical personnel, and emergency vehicles, and must cease using such medical facilities for military purposes in accordance with applicable international humanitarian law. It must also guarantee the wounded rapid, safe, and unhindered access by medical personnel and ambulances. Moreover, despite arguments that overemphasize the occupying power's security concerns, the international regime of occupation strikes a delicate balance between humanitarian aid and such concerns, namely the right of supervision as set out in Articles 23, and 59 to 61 of the Fourth Geneva Convention. These provisions cannot be interpreted as authorizing excessive or blanket restrictions based on security grounds. Only imperative military requirements with a specific temporal and geographical scope can lead to limiting humanitarian aid to a reasonable level. Consequently, Israel is not entitled to invoke security concerns to impose a general limitation on the presence and activities of third parties providing urgent and vital assistance to the civilian population. In the absence of serious and credible reasons, status may not lawfully prevent or impede the provision of humanitarian assistance where the basic needs of the civilian population are not being met. If conditions require certain measures to address the security concerns of the occupying power, they must be dealt with in accordance with international law and not in the framework of national legislation. As a result of the undue restrictions on the entry of humanitarian aid, Colombia considers that Israel, by preventing the entry of goods and supplies into Gaza, is in flagrant violation of the prohibition of starvation as a method of warfare in accordance with Article 54.1 of Additional Protocol 1 and Article 14 of Additional Protocol 2. Colombia considers it is urgent to ensure compliance with this obligation, given that the acute food insecurity faced by the population of the Gaza Strip is putting them at risk of starvation. This urgency was reiterated in the Order for Provisional Measures issued by the Court on 26th of January 2024 in the case of South Africa versus Israel, in which it requested Israel to, I quote, to take, I quote, all measures within its power to prevent the commission of all acts within the scope of Article 2 of the 1948 Genocide Convention. Mr. President, in accordance with its purposes, with the principles of the United Nations, the organization has always implemented a set of essential mandates in the occupied Palestinian territory. These include the consistent provision of vital humanitarian assistance to the Palestinian refugee population registered with UNRWA. Colombia shares the views expressed in several written statements, according to which the conditions and gaps that led the General Assembly to create UNRWA persist to this day and have actually deteriorated in recent years, making UNRWA's work even more necessary and irreplaceable than when it was founded. In this worrying context, Colombia recalls that a rule of international law does not apply in a vacuum, but in relation to the facts and in the context of a broader legal framework of which it is only a part. Therefore, given the current de facto and de jure context, by putting an end to or restricting the activities and operations of UNRWA, Israel, as the occupying power, would be effectively depriving the civilian population of the OPT of urgently needed supplies essential to their survival. The state of Israel is thus blatantly failing to fulfill its obligation under international humanitarian law by acts and omissions that interfere with or obstruct the presence and operations of the United Nations in relation to the occupied Palestinian territory. This behavior engages its international responsibility, a point which I will now address. Mr. President, the Court has a well-established tradition of addressing the consequences of wrongful acts in its advisory opinions. For example, in the advisory opinions on the wall, 2004, and legal consequences, 2024, the Court has provided guidance on the legal consequences of breaches of international law, setting out both the responsibilities of the breaching state and the obligations of other states. In this respect, the Court has already held that Israel's illegal presence constitutes a continuing internationally wrongful act, thus entailing its international responsibility. In the light of these precedents, Colombia invites the Court to supplement its guidance on the legal consequences arising from Israel's breaches of obligations, as set out in its two advisory opinions, and submits the following. Firstly, as reflected in Article 3 of the ILC draft articles on state responsibility, Israel is under an obligation to cease all illegal acts towards the United Nations, international organizations, and third states with regard to their presence and activities in relation to the occupied Palestinian territory. Specifically, Israel is required to rescind all measures that impede the provision of basic services, humanitarian aid, and development assistance to the Palestinian people, including the legislation passed in October 2024 to restrict UNRWA operations. Secondly, as provided for in Article 30B of the ILC draft articles, Israel has a duty to, I quote, provide appropriate assurances and guarantees of non-repetition, end quote, with respect to the facts on which this request for an advisory opinion is based. Thirdly, with regard to reparation for damage caused, although certain actions of the occupying power have resulted in irreversible damage, certain circumstances can still be redressed and restored to their previous state. And where possible, every effort must be made to obtain restitution. However, should this not be feasible, compensation is justified for the harm inflicted on the protected population. Mr. President, members of the court, in conclusion, I respectfully submit the following considerations on behalf of Colombia. Israel, as the occupying power and as a member state of the UN, as well as a party to the Fourth Geneva Convention and to the Genocide Convention, in addition to its obligation under international humanitarian law, remains bound by its obligations and responsibilities in the occupied Palestinian territory until such time as the Israeli presence is brought to an end as rapidly as possible. As the occupying power, Israel is legally bound to ensure that humanitarian relief operations be carried out without imposing unjustified or arbitrary conditions that directly infringe the fundamental principles and obligations enshrined in international humanitarian law, in particular, those incumbent upon the occupying power during occupation in the best interests of all protected persons under its effective control. Colombia also considers that by arbitrarily refusing to give its consent to UNRWA to continue its operations, and by hampering the work of other international organizations in the occupied Palestinian territory, Israel is condemning the population of Gaza to a worsening humanitarian crisis. Given that it is generally accepted that such consent should not be arbitrarily withheld in circumstances such as those faced by Palestinian refugees, such a refusal can only constitute a breach by Israel of its obligations under international law with regard to the treatment of the civilian population in question. Colombia argues that under the law of state responsibility, insofar as it is a continuing violation of its international obligations, which are the subject of the present request by the General Assembly, Israel is under an obligation to take all relevant measures to ensure the cessation, non-repetition, and reparation of such violations. Finally, Colombia is of the view that, as the court recalled 2 decades ago, the United Nations has, I quote, a permanent responsibility towards the question of Palestine until the question is resolved in all its aspects in a satisfactory manner in accordance with international legitimacy, end quote. And the same applies to the court as the principal judicial organ of the United Nations. Mr. President, members of the court, thank you for your attention. This concludes the statement of the Republic of Colombia.
I thank the representative of Colombia for his presentation.